It's David Fisher, Director and Founder of Immigration Chambers, Licensed Immigration Advisors for New Zealand and Australia. Specifically today, we're going to be talking about what happens if your visa is declined and what to do. So for here in New Zealand, we have different types of visas. We've got temporary visas and we have resident visas. So let's talk about both of them one at a time. Now, for temporary visas, you might have applied while you're onshore or while you're offshore. Okay, so first of all, if we talk about what happens when you're onshore. Now, it's going to depend on your circumstances at the time of the application. So if you have applied for a visa while you still hold a visa, right? In other words, you have a temporary visa, a visitor visa, student visa, work visa, and if your visa is declined while still holding that visa, you then have the right of reconsideration. Okay, so you have 14 days to submit a reconsideration request. That's the first option that you have, okay? A reconsideration request is not an appeal, okay? And it's not a new application. What a reconsideration request is essentially just a right that you have to ask immigration to review and look at the decision and look at the application again with fresh eyes. The application for a reconsideration must be submitted within 14 days, 14 calendar days. So that includes weekends. And the application will then be sent to a new immigration officer. The way to submit a reconsideration request is that you need to send a copy of your passport, a copy of the decision, and you need to submit any reasons why you feel that the application should be reconsidered. Now, this is quite important. If you simply send the application again and ask for a reconsideration, then there's most likely that nothing will happen. They'll look at it and they'll probably just decline it again. So you really need to outline what are the reasons why you would like them to reconsider it. So you need to point out any mistakes. For example, if INZ have omitted to consider certain aspects of the application. You need to point out any new documentation that perhaps you didn't submit with the first application, but you're submitting again. You need to point out a specific thing that you think immigration should particularly look at in your case. And you also need to pay a fee, so that's another thing you need to do. There's a reconsideration request fee, and just to let you know that immigration at their discretion can waive that fee if they agree to approve the reconsideration request. Now keep in mind that immigration still, it's the same application. They're gonna consider all the reasons for the decline, and so sometimes they won't necessarily wish to consider any new reasons or any change in circumstances. Okay, so they're looking at the existing decision, the existing application. But there's one thing that they can do, and that is they can consider, maybe the grant of a different type of visa. And in many cases, this is what has happened, that maybe they won't grant the initial work visa that you applied for, but if you've given satisfactory reasons why it should be reconsidered, maybe they'll consider something else, a visitor visa or something like that. Now, that's what happens if you still hold a visa for New Zealand. What happens if your visa has already expired? So you applied for your visa, let's say you applied on the 25th of April, and your current visa was expiring on the 1st of May, and then on the 5th of May, you received the decline decision. Now, first of all, what will have happened in most cases is that by the date of expiry of your visa, you will have received an interim visa. So an interim visa is something that bridges the time that you can remain lawfully in New Zealand while your application is being considered. So an interim visa will generally speaking, will be valid for 6 months from the date of granting of the visa, because assuming that an application is processed in due course, it'll take less than that to process. Or it will expire when you are granted the visa, so it disappears, you don't need it anymore, or 21 days after the decline. So if you receive that decline on the 5th of May, then 21 days from that date, the 26th of May, your interim visa will expire, and you would become unlawful at that point. So the reconsideration request is still available to you within 14 days because you hold a visa at the time. And the visa is an interim visa, but you still hold a valid visa, so you can submit that reconsideration request. The only thing to watch out for is that if you submit a reconsideration request within 14 days, you have only 7 days after that before your interim visa will expire. So there's a possibility that the reconsideration request will not be considered in time, which means you have a risk of becoming unlawful. And that is where you really should seek professional advice, because one thing that you really don't want to do is to become unlawful in New Zealand. Okay, but that is an option for you. You can submit that reconsideration request as long as you have that interim visa. In a case that you have not got an interim visa, so let's say, for example, like I mentioned before in the previous example, you submitted your application in April, your visa was expiring on the 1st of May, and so you got an interim visa. Now the interim visa is valid for 6 months. So from the 1st of May through to November, when that 6 months is coming up, you're lawful. But if your application has not been decided by that time, your interim visa could expire. Now, in many cases, immigration could consider the grant of another temporary visa. They have that option, they have that discretion to allow you to remain lawful. You should fight for that. But if you haven't been granted a further visa, you will become unlawful. So you're technically unlawful in the country. Now then, if your visa is declined, your application is declined while unlawful, unfortunately, you cannot submit a reconsideration request. Okay, so the reconsideration request is off the table. It's only allowed if you hold a visa in New Zealand. And the other case where a reconsideration request is not available is if you're offshore. So either if you're unlawful in New Zealand, or if you're offshore when you submitted your application, then the reconsideration request is not available. Now, you do have the option, of course, to simply go home or to give up on New Zealand altogether, or you would have the option of just applying again. So you can apply again for a visa if you're offshore, and this is the normal process. If you're offshore, you've applied for a visa, it was declined, normally you would just apply again. You don't really have a right of appeal or other process, you just apply again. If you're in New Zealand and you wish to apply again, you have to actually hold a visa, a substantive visa, not an interim visa. If your visa was an interim visa, I'm sorry, you can't apply again. If you hold another visa, visitor, student, work visa, something like that, you can simply apply again. Now, sometimes instead of a reconsideration request, a new application is warranted. And there are cases where maybe when you first submitted your application, something wasn't quite right. Maybe it was a work visa application and the labour market recruitment check wasn't done properly, or there was some documentation that wasn't quite correct, and a reconsideration request may not work, but a new application could work. And this is something that we see quite a lot, that an application has been declined, and really the easiest thing to do is to simply apply again. Other options that you have are, of course, a little bit more unique or bespoke. There are some cases where a mistake has been made by an immigration officer, and it may be appropriate to simply call them, okay? If you think that something has gone wrong and it's been a mistake, get your advisor or your lawyer, or by yourself, contact immigration, get them on the phone, email. If that officer themselves are not being responsive, contact a manager, contact the call center, talk to someone, find out if there is a misunderstanding or if there's a mistake. In many cases it's not. In many cases it's the applicant who's mistaken and it's a valid decline. But in some cases it does happen that immigration gets it wrong. And in fact, many times we've had application decisions reversed within a day of the decision, simply because there was a mistake or a misunderstanding on the part of the immigration officer. Now, immigration will often tell you they can't do this. They can do it. When they say they can't do it, what they mean is that their computer system may not have a function for it. But of course they can do it. It comes under their lawful discretion powers to reverse that decision at a certain level of authority. So that's one thing you can do. Another thing you can do is you can actually submit a complaint. Now, obviously, we used to refer to these as complaints or formal legal complaint about a decision. Immigration refers this to as client feedback. There's a client feedback process, and the complaint can be submitted through this feedback process simply online on the immigration website. You can either just simply fill in the form, or you can make a proper submission as to the reasons why you would like immigration to consider your complaint, or your feedback as they call it. Now, please keep in mind that there's not really any right of complaint simply because you're upset about the decision. Okay, if you don't like the decision, you think it's wrong, that the complaint process is not designed for that. The client complaints or feedback process is actually designed for procedural failures, or in cases where maybe you feel like you've been poorly treated by immigration. Maybe they've used the wrong type of language with you, racist, sexist, disrespectful language. But generally speaking, it's where you find that there's a procedural failure. For example, if you have applied for a visa and then you immediately receive a decline letter, and you're here in New Zealand onshore, you actually would normally have a right of reply for any reasons why they want to decline the visa. So if they simply send you the decline letter without first giving you an opportunity to respond to those concerns, then this is a procedural failure. And this is something that warrants a complaint. You can submit your feedback through the system. You explain that you never received any formal notification of these concerns, or a PPI letter as we call it. And we would hope that immigration would look at that and realize that it's a procedural failure and perhaps reverse the decision. Now, there might be cases where they did send these concerns, but you never received them. This could be a technical failure of the system. They do use computer systems, and those computer systems sometimes fail. If you can prove that you've never received anything by email, you never received a notification, then there's a possibility that that procedural failure will be recognized and possibly reversed. The complaints and feedback process is normally looked at quite promptly, and these complaints are looked at by managers, senior immigration officers, people who know what they're talking about, and you should expect to receive a formal outline of any reasons why they accept or refuse your grounds for complaint. But again, just keep in mind that grounds for complaint do not include that you are upset about the application being declined or that you disagree with it. You really need to point out what process failure you wish them to look at, and hone in on specifically bullet points of the things that you want them to consider. And this is very important when submitting a complaint. Now, besides the immigration complaints and feedback process, you also have the option to submit a complaint to the Office of the Ombudsman. Now, the Office of the Ombudsman is quite a unique and special function of New Zealand law, because it's essentially an office that has the, I don't want to say authority, but it has the warrant to consider complaints about government process, about decisions, any decision making that has gone on in the New Zealand context. But it's not binding. So the Ombudsman will undertake a review of any complaint and give a recommendation to the government, in this case to immigration, but this is not binding. In practice, immigration would always try to find a way to follow the Ombudsman's recommendations. But being non-binding, you have to just be careful about how much effort you want to put into something like this and how much hope you put on the result from an ombudsman. And I would suggest that taking a complaint to the ombudsman is really something that you should do with advice from a legal professional or advisor to consider whether it's something that you should put your energy into. We've had many cases reviewed by the ombudsman, and many successful results have come out of those cases, but they're usually quite unique, and they're usually things that we can really point to high-level failures on the part of Immigration New Zealand. Coming back to what would happen if your visa is declined and you are unlawful. I think this is a really important point to focus on here, because if you are unlawfully in New Zealand, you very seriously have to consider how long you're going to stay in the country, because there's a high risk that you could be put in handcuffs and deported at any moment, depending on the circumstances and the reasons why you have become unlawful. So your visa's declined, you're unlawful in New Zealand, maybe you tried a reconsideration request or not, but anyway, it hasn't worked out and you're unlawful. The first thing you should consider is going home. Okay, so that's the best advice that anybody can give you, is to go home. Because the moment you leave the country, you are no longer unlawful. And once you're home, you can then take stock of your life and the situation and review all the reasons that you became unlawful and what led to the situation. And you can consider maybe to stay home or to try again in the future. Now, trying again may be a long road. It may take a long time to come back to the country, or it may not, depends on your circumstances. You should really get advice about this before taking this decision, but that's really the first thing to consider. Now, if you cannot go home right away, or if you feel that it's not right to go home and that that actually there are genuine reasons that should be considered, to allow you to stay in the country, then the next thing you should consider is what we call a Section 61 request. Previously known under Section 35 of the previous law, now Section 61. And Section 61 is essentially the part of the Immigration Act which mentions that if you do not have a visa, you are unlawful and you should go home and you cannot apply for any visa. But under Section 61, we can submit a request to Immigration New Zealand for a visa. And a request is just that, it's a request, it's not an application. And this is the key point to understand. There is no such thing as a Section 61 application. It is a request. And being a request, the obligations under the decision maker are not as stringent or onerous as they are under a normal visa application. In other words, it is decided under the absolute discretion of the decision maker. And absolute discretion doesn't just mean that they can do what they like. They still have to have a good reason for refusing to consider or refusing the request. But those reasons do not have to be communicated to you. So it's a lot easier for immigration to simply refuse. Now, there's two levels of refusal. The first level is that they can take a look at your request and they can simply refuse to consider it, okay? Secondly, they can look at the request, agree to consider the request, but then they can refuse to grant a visa. So that's the two different levels of refusal that can happen to you under Section 61. And for this reason, you really should seek professional advice if you find yourself unlawful, because with no chance of knowing why they would refuse your request, it's very easy to find yourself just wasting time trying and trying again under Section 61 and never making it through. You really need to find someone who can help you to understand your circumstances and to present the case properly. If you are going to submit a Section 61 request by yourself, you can do it by email. You simply send an email to s and the numbers 61 at mbie.govt.nz. Now be careful, if you send an email to this address, whatever you send will be considered as a Section 61 request. You could send an email to immigration that simply says, "Oh, my visa was declined, this is really unfair, I think you should have given me a visa." And that one sentence will be considered a request under Section 61, and because it's only one sentence, doesn't fully explain the circumstances, probably going to be refused. So if you're going to send an email to that address, or if you're going to submit a Section 61 request, make sure that you really outline all of the reasons why you feel this request should be considered. You need to explain what happened. Why was your visa declined? What reasons did immigration give? Why do you disagree with those reasons? Why have you been unlawful? How long have you been unlawful for? And many more things. There's a lot to consider, and I would just suggest to explain as much as possible, be as open as possible, and really outline the reasons why you feel that you should be granted a visa. It's not simply enough to say, "Please give me a visa." You really need to explain why. And that's because under absolute discretion, the immigration officer who looks at your request doesn't really have to fish around to look for other information. They're not going to call an employer and ask if you really worked there. They're not going to call your partner and find out whether it's a genuine partnership or not. They won't make those inquiries. They're just going to look at what's in front of them. So make sure that what you put in front of them is everything that you think that should be considered, and that's very important. Now, if you do this, and if your Section 61 request is refused, it's not necessarily the end of the road. So after a Section 61 request, what we often recommend people to do is to, of course, if you're not going to go home or if you can't go home, is to take this request and let's say rehash it or reword it and resubmit it, but this time to the Office of the Associate Minister of Immigration. Now, this is a process that normally you should only do if you've already exhausted the Section 61 option, okay? Because when you send something to the Office of the Minister, they will consider whether you have already tried Section 61, and if you haven't, it's very, very common that they may simply say, well, no, we're not going to look at this because, we think it should go to immigration first. So once the Section 61 hasn't worked out and we're going to the Minister, it's kind of the same type of request. Now, when I say kind of, I want to be careful here because it's almost identical in a sense that you're arguing the reasons why you should be granted a visa. and they're going to consider it under their absolute discretion. They don't have an obligation to consider it, and they don't have an obligation to give reasons. When I say they, not he or she, because it will be considered by a decision maker who's employed in the ministry working under the associate minister. It's not necessarily going to be considered directly by the minister, him or herself, although it can be. So in that sense it's similar. But how it's different is that the office of the associate minister, these are not immigration officers. It's not INZ. And so that there can be other concerns that they might want to bring to the table, or there might be other considerations. For example, the minister's office may consider the political climate more strongly. The minister's office may consider your personal circumstances under a humanitarian sort of prism more strongly. I say may because, of course, again, it comes under absolute discretion. What we find is that there are often cases where we feel a visa should be granted and a person is unjustly unlawful and a visa should be granted. And quite often, immigration won't touch it. Maybe because it's a little bit political, but then the minister's office will agree. And so we often, when we are advising people who are unlawful, we advise you to consider that Section 61 requests and the ministerial request kind of go hand in hand, almost like a stage 1, stage 2 process, almost, but it depends on your circumstances. Now, besides all of these requests, reconsideration and everything, there's one other thing that can be done if your visa is declined and if you are unlawful, and specifically if you are unlawful, okay? You cannot appeal to the Immigration Protection Tribunal, otherwise known as the IPT. You cannot appeal against a temporary visa decision, okay? However, you can appeal against your deportation if you are unlawful. Now, appealing against deportation is different from appealing a decision, such as a residence decision, which I'll talk about in a moment. Appealing against deportation is quite different because you're having to explain and show the reasons why you should not be deported. It's not related necessarily to the reasons why you became unlawful. However, of course, the reasons for becoming unlawful are very important in considering that decision. The appeal must be submitted within 42 days, and there are some rules about how you calculate the 42 days. You can check that on the IPT website. But 42 days is the statutory right of appeal that you have if you've become unlawful, okay? Specifically if you've become unlawful. If that 42 days passes, you don't have that right anymore, and that's when you come back to Section 61 or Ministerial request. Now, it costs $700 to lodge an appeal, and also you're going to have some considerable legal fees if you seek professional advice. And when I say considerable, I mean any lawyer or advisor who really can do a good case is going to spend time on this, and that time is going to cost you money. You're going to be spending potentially thousands and thousands of dollars depending on the case. So you need to consider very carefully if a deportation appeal is really suitable for you. Now, just to give you an indication of what types of cases get approved and what types don't, and I want to be careful again because I can't give direct advice for your particular circumstances. Obviously, this is a video being published on YouTube for everybody out there, but just to give some general idea about the types of cases that the IPT is more likely to grant a deportation appeal for. These are cases where there really is a humanitarian nature to the circumstances. For example, there may be New Zealand children involved. Maybe there's a partnership with a New Zealander. Maybe there's a family member who's sick or unwell. Maybe the person who is subject to deportation is sick or unwell. And maybe that person cannot go home because there's not suitable treatment back home. Maybe there are other circumstances surrounding this person. For example, they have lived in New Zealand for a very long time. Maybe they're a very key person for the employment that they were in, right? So you can see there's a theme here that there's the unique circumstances for that person such that they cannot be deported. So in other words, the IPT is going to consider all of that together. What are your reasons why you can't leave? What are the reasons for staying? What are the reasons why you became unlawful? And it's not necessarily related to just the decision that led to the decline. The types of cases that we have seen where people have tried a deportation appeal and have been unsuccessful are situations that are kind of run-of-the-mill or ordinary. So in other words, let's say you might be a young, healthy, averagely educated person coming from a reasonably respectable country, where if you were to leave New Zealand, you could possibly find employment back home. And there would be no, let's say there would be no loss to New Zealand, there might be no loss to you other than the fact that you have to leave the country. So because of that, we often advise people to think very, very carefully before just jumping into a deportation appeal. But that option is there for you. Now, the other type of application that can be declined is a resident visa. Okay, now a resident visa application is very distinct from a temporary visa, because a resident visa, if approved, allows you to stay in New Zealand lawfully and permanently, okay? Depending on the type of residence, whether it's a standard residence or a permanent resident visa, but a resident visa allows you to stay permanently, so it's obviously there's a lot more riding on it, so to speak. Now, if you've applied for residence, whether onshore or offshore, based on any category for residence, and if that application is declined, you have the right of appeal. Within 42 days, you can lodge an appeal with the IPT, the Immigration Protection Tribunal. Some people refer this as immigration court. It's not a court, it's a tribunal, which is slightly below the level of a court. But this is the body that has the authority to determine appeals for immigration application declines for resident visas. Now, the first option that you have if your residence is declined is to lodge that appeal within 42 days. You pay $700 to the tribunal, and even if you don't take professional advice, fill in the form well, give as many reasons as you can as to why you think it shouldn't have been declined. The tribunal will take this seriously, and the tribunal will have access to all of the documents that were submitted with the immigration application. They'll have access to the entire immigration file, including what we call AMS, or in other words, the notes recorded on your file by immigration officers, any interviews you've had, any notations or documents for that. So the tribunal is not part of Immigration New Zealand, okay? The tribunal is staffed with, generally speaking, legally trained professionals. These are people who know how to do things properly, and they're not lay people. They definitely know how to do their job, which is to consider all of the facts, consider the reasons for the appeal. And even if you don't really make a strong case on your own part, the tribunal will consider your case. However, we would always advise to make a strong case, seek professional advice, and make sure that when the appeal is presented, that everything is actually well presented and that it's outlined, bullet pointed. Now, if we're submitting an appeal, or if any professional legal advisor is submitting an appeal, you would hope that there's research done regarding similar cases in the past. So this is what we call precedent. It's technically not precedent in the way that it can be understood with the courts of New Zealand, but we can refer to this as precedent because these are preceding cases. And if we can find cases that are similar enough that have been approved, we would refer to these cases. We would argue why your case is similar and should also be approved. So when you lodge an appeal with the IPT, you can claim two grounds of appeal. Okay, now the first is you claim that Immigration New Zealand simply got the decision wrong. Okay, now if you're doing that, you need to point out all the reasons why they got it wrong, refer to the instructions. Perhaps they've interpreted the instructions incorrectly. Perhaps there's some matter that has not been considered properly. Maybe there were procedural failures. And this is the main ground of appeal, okay? So this is what we see most appeals being based on. And there are a considerable number of successful appeals on this grounds. And this tells us that immigration often gets it wrong. We can't say exactly how many times they get it wrong because not every case is appealed. Many cases, once declined, they simply disappear. But we do know that a significant number of appeals are approved when it is pointed out that INZ got it wrong. Now, the other grounds for appeal is what we call special circumstances. So special circumstances have to be understood exactly as that, as special. Now, what does special mean in this context? It is defined relatively by the tribunal and by the courts in various decisions. Special circumstances are generally defined as circumstances that are uncommon, not commonplace, out of the ordinary, right? So in other words, if you simply, you like to live in New Zealand and you think that you should stay here because you've got a good job, well, this is not really special. This is actually the case for most migrants. Cases that we've seen considered as special, okay, well, we've had some recent approvals with, let's say there was an elderly woman who had actually given up her entire life overseas under the expectation that she would be granted residence under one of the parent categories. The application was ultimately declined because she failed to meet the instructions. There was some shortfall in her circumstances that meant she wasn't eligible, but all of her family was in New Zealand. She had zero family back home. In other words, none, like besides cousins or distant relatives. Not only was her son living here, but her son's wife and her grandchildren, the entirety of her family, her center of her life was here. She was in a position of health whereby if she was forced to go back home, she might not have survived very long. This is physically and mentally. And so the tribunal considered this case and determined that there were special circumstances. Other cases of special circumstances have been where perhaps a person was rightfully declined under, let's say, partnership. And in some cases, partnership applications are declined because maybe the partner has previously supported too many people for visas and therefore not an eligible sponsor. But the tribunal would consider that the relationship is genuine enough and that the family has become a unit here in New Zealand, and that the person has become so settled here that to not grant residence would be, I guess, a travesty. So when you're considering if you can make an argument under special circumstances, definitely take advice and definitely try to present as much information as possible about your life, about who you are, where you come from, what were your reasons for coming to New Zealand, what happened while you were in New Zealand, how have you been living here, what is your contribution to New Zealand. Really emphasize groups that you're a member of, charities, anything that you do in your spare time. Get as many supporting letters as possible from members of your community, from members of the community who are in positions of respect, such as doctors, lawyers, accountants, professionals who generally speaking have a position in society. This is quite important because when they consider special circumstances, they're not just going to grant you a visa for fun. They really want to see that you belong here. Now, besides submitting an appeal to the tribunal, the main option that we find that people will take, and this is even if you have tried with the appeal and it's not successful, and that is simply just to try again. Okay, so in many cases your visa your application for residence has been declined due to some shortfall in the evidential requirements or maybe in eligibility requirements. And of course, because there was a processing time of that application, in the meantime, you may have become more eligible, let's say. So for example, maybe you were declined under partnership because you didn't meet the requirement of 12 months living together, or at least you couldn't prove it. But now, of course, you can easily prove it. So apply again, and it should be granted. It will just take some time. Perhaps you applied under the skilled migrant category, and this was declined because you couldn't demonstrate that your job was a substantial match for the relative code under ANSCO, Australia New Zealand Standard Classification of Occupations, as they use as a benchmark. And perhaps after the application has been declined, you receive a new job offer, or maybe in the meantime your employment duties have been increased and you feel that it's going to be easier to prove it this time. So of course you simply apply again. Now it might not be so simple just to apply again, because of course you have to consider holding a temporary visa in the meantime. You need to consider whether you've still got your job, whether there's a future there, whether there have been any changes in policy. But generally speaking, trying again is an option that has to be considered. Another option that you have for a residence decline is once you've submitted this appeal and the appeal is refused, you could try to take this further. Okay, now I advise caution when trying to consider options beyond the IPT, and that is because it's not usually the case that this is the right way to go or the right strategy for most people. And so if you think that because your residence was declined, the tribunal case was declined, and if you want to take this further, if you really want to, speak to a licensed professional, a legal advisor, a lawyer, someone who actually has handled these types of cases before, because what I'm about to talk about is called judicial review. Now, judicial review is a process of law whereby you can submit an application to the High Court of New Zealand and request the court to review the decision which was made by the tribunal. And when they review this, they're not going to review the merits of the decision. It's not about whether or not immigration got it right or whether the tribunal should have granted you the visa. You need to identify this point of law, this procedural failure for review. And this is why it's quite a special type of, let's say, appeal that is not really the suitable approach for most people. So if you're thinking that because your appeal has been declined, you want to take things further, think very carefully the other types of options of simply trying again before taking a judicial review application. It can be very expensive, time consuming, and in many cases, even if you do get a positive result, it doesn't necessarily lead to the result that you want. And this is where you hear about people saying things like, we won on the law, but we lost on the facts, meaning that the point of law that was argued is successful. But when that point of law is applied to the facts of your case, it might not be the case that you end up getting the result that you want. So the winner in that case is the lawyer, which the lawyer will always get paid at the end of the day, I suppose. Now, besides these options, the one last thing I would say is that yes, you always have this option of submitting a complaint or as I mentioned before, the feedback process, or taking the complaint to the office of the ombudsman. And again, I would just say, be careful, take advice. Complaining because you're unhappy often will lead to just further unhappiness. So if you have something which really is a genuine reason for complaint, a procedural failure, some failure of process that immigration has followed, or that the tribunal maybe has missed out, then maybe it's worthwhile. Otherwise, think very carefully about this. Okay, so those are the main options, the main things that people can do if they have a declined visa. We've talked about what happens if your temporary visa is declined. We've talked about what happens if your resident visa is declined. As usual, if any of you have any questions that you would like addressed specifically about your case, feel free to contact us. The details are below in the video. Contact any licensed professional. If you feel like you want to do it on your own, still, it's a good idea to talk to a professional, even just to get some advice. Most people will offer you at least a 10 or 15 minute consultation without charge. And if they're trying to charge you for